We are live. Thank you for your patience. So it is my very, very great pleasure to start this final conference in the Cycle des Conférences, the faculty seminar series that we have here at the University of Ottawa. And I think it's wonderful that we can have a presentation from someone who's outside of our hemisphere, because it really allows us to expand our reach and the interest that in exchange and scholarly discussion. Before we get started, I would like to acknowledge that the University of Ottawa is situated on the unceded territory of the Anishinaabe Algonquin people, and I would like to recognize their traditional role as guardians of this territory. We would like to express our honor and respect to them, as they have been traditionally the caretakers of this land. And particularly, I would like to welcome all Indigenous peoples, whether they are from here or elsewhere, if they are joining us, and to recognize the leaders, both past, present, and future, of the local Indigenous communities that take care of this land and across the country. Without further ado, I would like to just give a few very brief words of introduction to our guest speaker, Professor Shruti Bedi, who is joining us from India, from Panjab, where she is a professor of law at the University Institute of Legal Studies. She's an international fellow with the National Institute for Military Justice in Washington, D.C. She's also been a visiting professor of law in Indonesia, and is a director for the Center for Constitution and Public Policy at her home institution. She is an expert with a wide range of interests that touch on, that range from constitutional law to specific criminal law. And in particular, she has a strong interest in national security and some of the issues that arise when you're dealing with emergency powers, something that she spent quite a bit of time thinking about. For those of you who are joining us from outside of Canada, we have just wrapped up a series of hearings that were required by law following the triggering of the emergency powers provided for here in Canada, that were launched as a response to the trucker convoy in earlier, or however you want to express it, relative to the events that occurred in the capital in February of 2022. And so I think it's going to be very interesting to listen to Professor Bedi talk about the Indian experience of using emergency powers, because I think there will be some very useful lessons there. So I'm going to stop there. I'm going to hand it over to Professor Bedi, who will share her screen with you. I have asked her to leave some time for questions. So if you do have questions at the end of her presentation, please either raise your hand, or if you prefer, you can write a question in the chat, and I will keep an eye on that. So without further ado, I'm going to go dark and cede the floor to Professor Bedi. Welcome.
Thank you so much, Professor Jennifer. I hope I'm audible and it's not I hope everyone can hear me now. Well, I think a lot of people were having trouble logging in. There's a problem with the link sharing, but I have shared it with the people from India who did ask for, something different, because when they joined, it wasn't letting them enter. But I think we seem to have resolved that, and I'll continue with my presentation for today. It's a pleasure indeed to be a part of this. And this is, as Professor Jennifer has said, is an extremely important issue, not only in India, but I think the world over, mainly for the reason that even though emergency as an act or a situation was envisaged during the olden days, in fact, if you look at the classic Roman, that is the place where it originated from. It really was a place, that was the time when it began, but it was something which started out as a dictatorship, because under the Roman regime, the powers were handed over to a dictator, And then, however the dictator handled it, he had absolute powers during the time of the emergency. And once the emergency was over, he would give the power back to the people or the parliament or the institution that was regulating them. But anyway, today I will be speaking to you about the theory of emergency powers in India. What are the constitutional provisions and the decisions of the various courts, particularly the apex court in India, the Supreme Court, which is relevant for the reason that, like Professor Jennifer has just said, that Canada also experienced the imposition of emergency powers because of certain protests launched by the truckers. Okay, I hope this is visible to everyone, the screen. Well, as far as the Indian Constitution is concerned, I would like to share that the Constitution of India provides and envisages 3 types of emergencies. I'm sorry for the interrupt. I mean, sorry for not being able to speak clearly. I think there is a little bit of interruption here and there. We'll have that sorted as we go. But anyway, coming back to the types of emergencies, see, the Indian law has been codified. So that is an important point. The codification has taken place, like in Canada, the difference being that emergency in India is codified under the Constitution, which is the highest law of the land. Whereas in Canada, you have the Emergency Act of 1988, which envisages 4 types of emergencies. So I will compare these 2 provisions briefly, but particularly focusing on the Indian powers and the emergencies which are visualized. So we have national emergency, wherein under Article 352 of the Indian Constitution, the president has the power to proclaim a national emergency on 3 accounts: due to war, due to external aggression, and the third one is due to armed rebellion. When I say war, it is when both countries or when 2 or more countries are fighting as an acknowledged method of conflict with each other, which is termed as war in the international context. That is a situation which would justify the proclamation of emergency. Now, India's constitution envisages a parliamentary system of government, where the parliament is the legislature. The head of the executive is the president, who is a nominal head. But the president, who is also the head of the country, so to say, has been given the power to proclaim or declare a state of emergency. So national emergency can be declared on 3 grounds: war, which I have just spelled out; external aggression, which means that there is attack from one side, from one country, which justifies the imposition of emergency because it is a threat to the sovereignty and integrity of the nation. And the third is armed rebellion. So whenever in the country there is a rebellion which occurs, and that rebellion is satisfying the threshold of being a threat to the sovereignty of the country, that would justify the declaration of national emergency. We have the second kind of emergency, state emergency, which is declared under Article 356. This is, so India is divided into different states, and state emergency is something when a particular state cannot function in the normal course of business, when there is a failure of law and order, when there is a failure of the constitutional machinery of the state. The president again has been empowered to declare state emergency. And the third is financial, which is when there is a financial crisis in the country. Now, I will first deal with the national emergency, which I think would be more relevant to the Canadian context of how Canada has declared a state of emergency in February of this particular year. Now, national emergency is declared in India through the president, who has the power. So the three grounds, whenever anything of such nature takes place and the president is satisfied that there is an imminent danger to the sovereignty of the nation, the national emergency can be declared by him. For the revocation, which means the taking back, which is again a provision which is similar to Canada, the president can issue another proclamation revoking the proclamation of the state of emergency. Of course, there is a provision which was added after an amendment because there were some problems which had occurred in the past when the emergency had been imposed for the third time, which is in fact, I will be discussing, which is the most controversial of the three emergencies which has been imposed in India till date under the national emergency category. So now, of course, the President of India can only declare an emergency when the cabinet, which is headed by the Prime Minister, gives the decision or the advice to him in writing. He cannot declare it otherwise. Moreover, the Parliament has to approve this proclamation. So there are already two checks and safeguards that I have spoken of. Number one, the cabinet has to give this advice to the president in writing. Number two, there is parliamentary oversight. It has to be placed before the Houses of Parliament. The proclamation which is issued by the president can only carry on for 1 month from the date it is issued, unless both houses of the parliament approve it by a resolution which is passed by special majority. And this proclamation, once approved, will last for a period of 6 months. So that is how it will work. Right. So the three emergencies which have taken place till date is the first one in 1962, which occurred on 26th of October 1962 when China attacked India. Although that lasted for a couple of months, but the state of emergency carried on, and it was still it was still there when Pakistan attacked India in 1965. The emergency, of course, ended on 10th of January 1968 ultimately. It did not end before that. So this is the first one. This is when the ground was justified as on the ground of war. The second emergency was in 1971 when India launched the Bangladesh Liberation War. This was a liberation of the country which is now Bangladesh. It lasted for 2 weeks only, and the hostilities had ended on 17th of December 1971. But this continued because of certain reasons for a longer time. The third and the most controversial of all the three emergencies is the one which was declared in 1975 on 25th of June. Now, this was issued by the President of India at the behest of the then Prime Minister Indira Gandhi. The reason for that declaration, let me also share with you that one of the things was that prior to the 44th Amendment of the Constitution of India, The ground of declaring a national emergency was internal disturbance, and it was not armed rebellion. That was changed later on because of this third emergency, which I'm talking of. So what had happened was that in 1971, Indira Gandhi had been elected, and her opponent had filed a case in the, I'll in fact take you to that case which occurred. So this is the particular case, Indira Nehru Gandhi versus Sri Raj Narayan. This is a case of 1975. Now, Mr. Raj Narayan, her opponent in the election, had filed a case in the state high court, in the Allahabad High Court in 1975. The Allahabad High Court had held Indira Gandhi to be guilty of malpractices during elections and had ordered that she could not contest elections for the next 6 years, and she was forbidden from that day to continue as the Prime Minister. Now, this, of course, was challenged. This decision of the State High Court was challenged. She went in appeal, Indira Gandhi went in appeal to the Supreme Court. The Supreme Court gave her a few weeks, which she had asked for. And before the date of a hearing, which was on the 26th of June, 1975, on the night of 25th June, 1975, Indira Gandhi asked the President of India to impose another kind of emergency, which was on the ground of internal disturbance. So without consulting her cabinet ministers, she asked the President to immediately declare internal emergency. I mean, it's popularly known as internal emergency, but of course it was national emergency on the ground of internal disturbance. And basically it was a misuse of the power because of the fear that she would lose the case and she would lose the Prime Ministership of India. Now, this happened on the night of 25th of June, 1975. And during this time, when the internal emergency was in operation for a period of 21 months from June 1975 to March 1977, when both emergencies, the one which was on previously, were ended, was the fact, what happened was that there was a huge amount of misuse of power by her government. There were mass arrests carried out. There was complete curb on freedom of expression, the rights and liberties of the people of the country. There were a lot of protests against this kind of attitude by the government. But of course, the people were rounded up, especially the opposition leaders and other people who dared to protest and speak against this, and they were all put behind bars. I will come back to this case later. But just let me go back to what I was talking about. So this was the single most controversial emergency which was imposed in India. And I think this would be relevant to the Canadian context because the Canadian Emergency Act 1988 allows for emergency to be imposed on 4 grounds: public welfare, public order, international, and war emergency. And recently, the emergency which has been declared on February 14, 2022, by the convoy of truckers against the COVID vaccination program and the other restrictions, has compelled the government and the Prime Minister Justin Trudeau, to pass the public order emergency under this act. This carried on only till February 23rd, 2022. So in terms of time, this is not too long a period of time. It is a very short period of time, but the question remains that are these emergencies correctly imposed, and do the imposition of these emergencies really justify the threshold, the criteria for imposing an emergency? Now, as far as India is concerned, I would like to also talk about the safeguards which are present under the Constitution. Like I said earlier, the emergency has to be approved by both the houses of the parliament. If the Lok Sabha, which is the lower house, is not in session, the moment the Lok Sabha assembles or sits, it has given 30 days. Within those 30 days, the Lok Sabha can approve. And this will continue, this emergency can continue for a maximum period of 6 months. And if it needs to be continued subsequently, it needs and requires the approval of the parliament. The parliamentary approval has to be carried out through special majority and not simple majority, which means that 2/3 of the members need to pass that resolution approving the continuance of the emergency. Now, I saw a similar provision even in the Canadian Emergency Act, where it requires the approval of the parliament. And if it is not in session, the session may be called to look into this as well. As far as the revocation is concerned, the parliament has the power, particularly the Lok Sabha, by passing a resolution, can cancel or revoke the emergency. Of course, the president can also do it at any point of time. Plus, additionally, if 1/10 of the members of the Lok Sabha give a notice in writing to the speaker, then they would have the power to take up the issue and pass a resolution if they so desire to revoke that emergency. Now, coming back to the Indira Nehru Gandhi case. So what had happened was that this internal emergency had been imposed wrongly by the Prime Minister at that point of time. And this is the case. Subsequently, this was taken up as an issue, whether this is right or wrong. And what had happened was also the controversial 39th Amendment of the Constitution, which was passed in 1975 on 10th of August. This was passed because the reprieve that had been given to Indira Gandhi in June 1975, which had put a stay on her being forbidden to continue as a Prime Minister of India, would last till August 1975. So just a day before the hearing in the Supreme Court of India of this case, the Parliament of India passed the 39th Amendment Act, which had added Article 329A to the Indian Constitution, the provision which barred judicial review. And it said, this provision said that on certain matters and questions of election of the Prime Minister, the President and the Vice President and the Speaker of the Lok Sabha, the courts could not interfere. The courts could not deal with this question. So judicial review at that time, in a completely dictatorial tendency, was taken away through this amendment of the Constitution of India. Now, this constitutional amendment was challenged, and it was held to be violative of the basic structure of the Indian Constitution. In fact, Indira Nehru Gandhi, this particular case, which you can see on the screen, is one of the first few cases which applied the doctrine of basic structure and held that this is a violation of a basic structure principle, which is separation of powers. Now, if we all understand, in any democracy, for a democracy to be successful, the organs must clearly have separation of powers. The judiciary, the legislature, and the executive must function in their own separate spheres. It is imperative for a thriving democracy. Now, as is the case whenever any kind of emergency is imposed, the repercussions can be felt through many mediums. So there is an impact on the center-state relations. Of course, when national emergency is declared, the executive at the center becomes all-powerful. It takes all the decisions which are necessary for the entire country. Even those which the states have to take ordinarily in the normal course of business are taken by the executive. Then the laws. So the laws are also in India, the legislative power is also given to the central parliament. The state legislatures If they need to make a law, they need the approval of the parliament for that. But otherwise, all laws, even for the states, will be made by the parliament. Financially also, the center can pass any kind of order restraining or imposing certain constraints on the use of finances. The next impact or effect of national emergency is on the life of the Lok Sabha. So the Lok Sabha, which is the lower house in the parliament in India, is the house which is directly elected by the people, and the elections are held every 5 years. However, if at that time the national emergency is in operation, then the Lok Sabha elections cannot be held and they are postponed by 1 year at a time. Of course, the more important impact is on the civil liberties, the rights, the freedoms, the fundamental rights of the people. Now, like I said, during that time, what had happened was that the rights had been suspended. When the imposition of internal emergency had taken place. So what happens is when national emergency is imposed, the fundamental freedoms like freedom of speech and expression, the freedom of assembly, the freedom to form associations, etc., is suspended. And one very more important fundamental right, which is the right to life and personal liberty, along with certain additional and corollary rights are also suspended, not directly, but indirectly, because you cannot move the court during that period of time. So what had happened, even in the Canadian imposition of emergency, what had happened was that when the Canadian Emergency Act was invoked, the question was relating to the civil liberties of the people, which was particularly regarding the freedom of speech and expression, the freedom to assemble, which the truckers had got together. And similarly in India, when I speak of the 1975 internal emergency, the civil liberties of the people were trampled upon mercilessly, in the sense that there were mass arrests. People could not express their opinion. If they wanted to speak something against the government or they wanted to protest, they were picked up and arrested and put behind bars. So the fundamental rights had been taken away during that period of time. And this led to a lot of grievance amongst the people. And ultimately, the power, if the executive becomes too powerful during an emergency, which is of course the situation, but if it is misused beyond whatever is required and the limit which is imposed on the exercise of that power, there is going to be some kind of a revolt. So what happened was that people were arrested. They filed a habeas corpus petition, which was entertained, which was taken up, and the arrest was stayed and they were released. However, when the state went to the Supreme Court in appeal, and this is the very infamous case that we have, which is popularly known as the habeas corpus decision, which is ADM Jabalpur versus Shivakant Shukla, which is the decision of 1976, wherein the question was that if Article 21 of the Indian Constitution, which guarantees the fundamental right to life and personal liberty to its people, is suspended during national emergency, can people be released through a habeas corpus petition? And this decision was granted against the fundamental rights of the people of the nation. And that is why it is known for its adverse and the negative decision, which was of course rectified later on by the same court. But at that point of time, the people, the judges did not stand with the people. They stood with the executive. The executive was extremely powerful in India at that point of time. And the decision, the judiciary I would say, was sort of weaker in that sense, not to be able to stand up against what was the misuse of the power by the executive. However, this decision, which was a decision given by 5 judges of the Supreme Court of India, the decision was given 4:1. There was one judge who was in minority, Justice H.R. Khanna, who is recognized as a stalwart of Indian constitutional law even today for protecting the fundamental rights of the people. He gave the minority decision in favor of the people of India. He said that right to life and personal liberty is a right which is inherent in the people because they are human beings. It is not ours to give or ours to take away. And even an emergency does not justify the denial of this very basic right. So he is recognized as the person who stood against the might of the state even during that time. Subsequently, the 44th Amendment to the Constitution took place in 1978. And in 1978, it was clarified that these rights, Articles 20 and 21, could not be suspended during emergency since they were the most basic of all rights. Another question which keeps coming up is the question of judicial review. Can the courts review the proclamation of emergency? Once the president has passed an order of emergency and it has been approved by the parliament, can the court step in to review the validity of that emergency? And that has been held, yes. It has been affirmed by the Supreme Court that yes, the judicial review will lie. And this has been held in the case of Minerva Mills versus Union of India in 1980. I will also like to share that as I was going through the material available on the internet about the proclamation of emergency in Canada, the question which was taken up by the court was this very particular point, whether the emergency has been imposed rightly, does it satisfy the threshold that it is supposed to? And that can only be analyzed on the basis of the material which would be produced by the executive to show that they were justified in imposing this emergency or not. Now, the question remains that can the courts go into the material on which the executive has relied upon? So what happens is that if you recall, I had told you that the President of India can proclaim emergency only once he has received in writing this advice from the cabinet headed by the Prime Minister. So what Minerva Mills judgment has held is that the courts cannot go into what advice was tendered by the cabinet, by the Council of Ministers to the President, but they can have a look at the material. They can scrutinize and review the material on the basis of which this decision was taken. So I think this is something which could be of assistance to the Canadian context as well. So that was all about national emergency. I will quickly run through the state emergency or president's rule, which is the second kind of emergency. This is again something which has been used liberally, I can say, where India is divided into different states, and if there is a situation where the constitutional machinery of a state cannot be carried on in accordance with the provisions of the Constitution, the President of India has the right to proclaim a state of emergency. And of course, it has to be approved by the Parliament within 2 months. The national emergency has 1 month. Here it is 2 months. And this is the same provision that the satisfaction of the president is open to judicial review, whether or not the state emergency has been imposed rightly or not is not beyond judicial review. Now, presidential powers is during state emergency that he takes up all the functions of the state. Actually, the governor of the state, who is the executive head of the state, the powers of the president are entrusted to him rather than the elected government of the day. He is the one who will function in the name of the president and carry out the governance of the state. Here, the powers of the state legislature are transferred to the parliament, the central legislature, and during this time, the elected legislature of the state is dissolved. It is the chief minister of the state is dismissed, and that is how it continues. Now, if you look at this particular slide, the number of times that the state emergency has been imposed in India is a whopping 133 times. So it just tells you that there are many times when it has been imposed at the behest of the executive wanting to acquire power in a certain context. And that is the reason that we have, since 1950 onwards, 133 times till date that this emergency has been imposed. Now, one of the most famous cases pertaining to state emergency is the 1994 Supreme Court decision of S.R. Bomai, which laid down certain guidelines. And it is post this decision, we find that there is a reduction in the number of times the state emergency has been imposed because of the guidelines which now have to be followed before state emergency can be imposed. So there are limitations. There is a certain amount of safeguards which have been imposed by this particular case decided by the Supreme Court, which has laid down these guidelines. And so I'm not going to go into this into detail. I will be sharing. I have already shared this PowerPoint with Professor Jennifer. She can share it with you further if that will be useful for everyone. So the third emergency is financial emergency. If there's a financial crisis, the president can proclaim financial emergency. Of course, in India, this kind of emergency has not been imposed because such a situation has not arisen till date. I would also like to share with you, everyone, that there was a very well researched article on this particular aspect, Constitutional Theories of Emergency Powers and the Limits, which also analyzes beyond the constitutional theories of general emergency powers and the various models of emergency powers given by Carl Schmitz, Dyson-Horst, Gross, and various other jurisprudential philosophers. In addition to that, we have also explored the perspectives from the Vietnamese, Indian, and the Canadian angles. This is an article which was researched by Professor Sebastian Lafrance, myself, and Hannah Gregorio. This is available at this link, which I have shared. So if you would like to read further, this is what is available to you. So thank you. I think the time for my presentation is at an end. I will now stop sharing the presentation and we can have, I hand over the area to Professor Jennifer.
Thank you very much, Professor Bedi. This was a really fascinating, albeit short, I mean, you were incredibly concise overview of emergency powers in India. And I think that that you've highlighted some interesting elements that certainly resonate in the Canadian context. Before I'm going to hand it over to anyone who's got questions, I just want to acknowledge that Terry Skolnick is with us, and I neglected to mention that this conference has been co-presented by our Center for Public Law here at the University of Ottawa, which brings together public lawyers, constitutional lawyers, administrative law lawyers, criminal lawyers, charter experts. And so certainly the context of national emergency is one of those subjects that brings many of those elements together. And the declaration of an emergency and the fallout thereafter has certainly been a subject of interest by our Public Law Center members. So I wanted to acknowledge that they're here. I am now going to open the floor to those who who would like to ask questions. So you can either raise your hand or you could put the question in the chat if you are disinclined to open your screen. I know it's late in India, so just feel free. Otherwise, I can let Professor Bedi continue with more discussion. I'm sure she has hours of discussion that she could provide us. I'm sure that Maître La France has a question. He's being quiet.
No, sorry, just had some problem with my mouse
We
here.
can't hear you though.
Oh,
That's
can't you?
There,
Yeah.
there, yes.
Okay, excellent. Sorry, there was some delay with the connection of the microphone. My apologies. No, I have a question. What would you say is the most striking difference between the Canadian and the Indian regime when it comes to a public emergency like this?
Professor Sebastian, that's something, it is so relevant because this was the question in my mind as well. So what I find is that because the emergency powers in India come from the Constitution of India itself provides for, envisages a state of emergency. Whereas in Canada, it is a legislative enactment. It is not provided under the Constitution. So I think the powers which may be given to the executive in both countries would be different. The justification of the imposition of emergency would be different. Why? Because, like I said, of course, Constitution is also a legislative enactment, but it is the highest law. So if the highest law is envisaging a state which is different from the normal, which allows for powers to be concentrated in a period of time, for a period of time, temporarily, within an institution, which means that the civil liberties of the people are impacted. If it is provided by the Constitution, somehow there seems to be more of a justification rather than if you compare it to a normal legislative enactment, a statute. So people would have the tendency to question the invocation of a statute more as compared to a constitution. So I think that is where the sanctity, I would say, behind the allowance of the state of emergency, which is the difference between India and Canada, really happens. And if I would also be allowed to state that, although when I was reading the provisions of the Canadian Emergency Act of 1988, Canada, of course, except for the previous time when under the War Measures Act, they had the state of emergency, which I think was imposed by Trudeau's father himself at that point of time. It has not really seen a state of emergency besides this one. Now, the difference in India is that we've had national emergency 3 times and state emergency 133 times. So it is a subject that we have thrashed and explored tremendously at various levels. And we have come to a conclusion where we can say that there are numerous safeguards now currently in place for limiting the misuse of the executive power during the state of emergency, which means because we went through a bad time in 1975, we sort of learned our lessons. We amended the higher law. We amended the constitution to put more limitations. The reaction of the people, in fact, was that, after the internal emergency was lifted in India in 1977 and the elections took place, Indira Gandhi lost badly. The people completely voted her out of power. So this was the voice of the people also, stating something that they really truly felt about what had happened during that imposition of emergency. And of course, the Supreme Court of India has been extremely active. So judicial review has taken place at an extremely fast pace in India, where they have analyzed the validity of these imposition of emergencies. They have held many, many times the state emergency, which has been imposed to be wrongly imposed, and have struck it down even after the parliament has granted approval to the proclamation of emergency. So we've had this exercise of the safeguards at various levels happening. For Canada, I feel it is something like treading into new territory. The law itself is not really old. This is the first time that emergency was imposed. It was a very short duration of time as compared to what happened in India. But of course, and I think the subject is still under review by the courts. I think the committee which was appointed is still to give its decision, because they get 365 days to give their report, the parliamentary committee. So I think for Canada, it is baby steps, but there are things which it can learn and take lessons from India in terms of how to safeguard the exercise of powers, so to say, and how it can evolve and strengthen the limitations which put a check on the misuse of powers during the state imposition of the state of emergency. I hope that will
Thank you very much.
answer a little bit of
Yeah.
I
your
think
question.
so. I don't know whether you have a
very well.
follow-up,
Thank you.
but everyone else is being very quiet. I don't know whether that's just they're patiently waiting their turn, but now's your chance to ask a question. If no one else does, I'm going to exercise the Vice Dean privilege. But I see there is a question. Please go ahead, Mr. Rumastan. You will need to unmute yourself.
Yes, good morning or good afternoon. Here where I am in Rwanda, Central Africa, it's already night. But it's a very interesting topic, and thank you for your presentation. And thank you for choosing this topic as well. I am on the feeling that if the emergency powers are not embedded in the Constitution, that gives actually more power to the judge to exercise the judicial review. What do you think?
Thank you, Professor Dennis. I'm not too sure. I have not been able to exactly get your question. So if you could really pinpoint the exact point.
My question is centered around the feeling that I'm having that if the emergency powers are not embedded in the Constitution, that discussion on the power of the judge to exercise the judicial review is simpler, because he will not fight against the Constitution itself. He will fight against the lesser level law that might automatically give him.
So as I understand, I'm sorry again, but as I understand, you're saying that if the emergency powers are not provided for in the Constitution, the power of judicial review is greater. Yes. Okay. So if the emergency powers are not provided in the Constitution, which means it's an extra legal measure, or are you saying if it's provided under a legislative enactment, that is the comparison that you're drawing here? Or are we saying that? Okay.
Absolutely.
So, of course. So, yes, judicial review becomes easier in case there is a legislative enactment. The power which is given to the judges would be greater in that sense, in the sense that you can test the constitutional validity of the entire statute itself, whether the very provision of the state of emergency through a statute is correct or not, is valid or not. It can be tested against the basic law, the constitutional law of the land. So that is a higher power of judicial review, which comes from that basis itself. So I think, of course, that sort of a power gives, and I think that's a very good point, Professor Dennis, you pointed out in response to what Professor Sebastian had asked. In fact, that is the difference really between a provision being contained in a constitutional law and a provision being contained in an ordinary statutory law. And that is something which we really need to understand. So see, a state of emergency is a sort of an extra legal measure. It is something which is out of the ordinary. And so let me go back to the Roman time when when the one person or one authority was given the entire powers to control the emergency and to tackle it. Subsequently, we relied on his integrity to not misuse of the power and hand over the power to the people when the state of emergency was over. But it was a reliance, too much of a reliance on one person, which could be misused, where there was a higher chance of a misuse. And that becomes unpalatable in today's times of a democratic environment. And that is why having a provision for emergency, envisaging a state of emergency, I think is important in the constitutional context itself, because if the Constitution envisages and if the Constitution itself provides the limitations, it is, the executive would be bound by all means not to be able to overstep it from any angle, because the judiciary, being the guardian and the protector of the Constitution, would have to ensure that the limitations imposed on the exercise of the power of the executive are maintained at all costs. In a legislative enactment, I think, and I feel, it somehow becomes easier for the executive to overtake the powers, and there is a higher chance of misuse of powers in such a context. So thank you, Professor Dennis, for joining from South Africa, from Rwanda. I think the time would be really odd, but thank you for being with us and for being a part of this lecture, and thank you for this question.
Thank you. That was interesting. I will pass the question microphone over to I think it's John Keys, right? It only says J Keys on your identification. Please go ahead with your question.
Thank you, Jennifer, and thank you, Professor Bedi. This is fascinating, listening to how these things have unrolled in India. I have two related questions. One is that it's been over 40 years since there's been a national emergency declared in India, I understand from your presentation. And I'm wondering, what does that say about the state of national emergencies and the government's preparedness to invoke that as a tool to deal with situations? Is it sort of becoming a bit of a dead letter in India because it hasn't been used in over 40 years? And then my other question has to do more with, in Canada, one of the critical issues in declaring the emergency is whether it was necessary because the authorities did not have the powers that they needed to deal with the situation. That's one of the requirements for declaring the emergency in Canada, that the existing powers of authorities are inadequate to deal with the emergency. And that's a real issue. It's been coming up in the inquiry, which has recognized that it looks like the blockades at the border were pretty much ended before the emergency took place. It looked like the police were just about ready to clear the blockade in Ottawa before the emergency was declared, and yet the emergency was declared. And so my other question is does the scope of ordinary powers or non-emergency powers have something to do with the decision to declare or not declare an emergency in India as well?
Well, thank you, Professor John Keys. It's great. Both these questions are extremely interesting and they provoke us to think as well. Well, as far as your first question as to whether national emergency, it's been more than 40 years. Thank God it's not been imposed for all this while. If you see the three grounds on which national emergency can be imposed in India, which is war, which is external aggression, and the third ground is armed rebellion. So it is only and only if either of these three grounds occur, take place, can a national emergency be proclaimed. So thankfully, we are not at war. Thankfully, the aggression, although we did have a certain amount of aggression in 1999 from Pakistan, which was a sort of it's not really like a full-fledged war, but it was tackled at the level of the executive itself. The defense forces in India were able to handle it, and the government did not really feel the need to proclaim a state of emergency. They handled the situation. And as far as the third ground is concerned, initially the ground which was mentioned was internal disturbance, which was extremely vague. It was subject and liable to misuse. And it was the ground which was misused by the government of the day in 1975. And that is the reason the 44th Amendment of the Constitution in 1978 changed internal disturbance as a ground and changed it to armed rebellion, making it extremely specific that only and only if there is a rebellion which is armed, which is threatening the sovereignty of the country, that is the situation which would justify the invocation of emergency. Now, these three grounds have not really taken place in the sense that, to satisfy the threshold that there is a threat to the sovereignty and integrity of the nation as such, which justifies the imposition of national emergency. We have so many different forces at our disposal. We have the police force, we have the army, the other defense forces. And if there is a situation which demands that these forces are sent out and asked to handle a situation, they do so. If you don't really need to declare a state of national emergency. It's a huge country, India, and it would be really unfair and unjustified if the threshold is not met. And that also is an answer to the second question, Professor John. When we speak of the Canadian context, and as you yourself have pointed out, that even before the emergency was imposed, the blockades were almost removed, or the police had stepped in. And when I was reading through the imposition of Canadian emergency, I also came across this very point that even though the emergency had been imposed, the forces were called in to sort of disperse the truckers and the convoy. And ultimately, they did use the power of the state to dismiss that kind of a public order situation. The ground of emergency in Canada was public order. Now, that is, again, I would say, a huge ground. And maybe if it is made more specific, if it is categorized, because one of the questions for judicial review, as I understand, before the Canadian courts is as to whether the threshold was met in the Canadian context as well, which justified the imposition of emergency at that point of time. And that is the question which the courts will be deciding, I think, once the committee submits its report regarding the material on which the decision of the government was based. And if you really feel, if the courts feel that the threshold is not met, it would be categorized as a misuse of the powers of the executive, a wrongful imposition or declaration of emergency. And frankly, from the Indian point of view, if I may say so, I would say that it would not justify the imposition of emergency. Also in India, if you notice that the three grounds, that is war, external aggression, and armed rebellion, do not envisage a situation maybe even of a pandemic, a public health emergency. maybe the Canadian context, the Canadian powers would envisage a public health emergency under the foregrounds that it has. And that is something I was thinking of when I was preparing for this presentation today, because one of the grounds in the Canadian context is the public welfare emergency. And I think that is again something which can be used or rather misused, you know, at the convenience of the government. So our experience in the Indian context has taught us that it's important that you're specific and that we are not vague, because more vague the term, it is more susceptible and liable to be misused. Everybody enjoys power. And at moments like this, you know, there is a saying which says that absolute power corrupts absolutely. So I think that is something that we need to keep in mind.
Thank you very much, Professor Bedi. You know, one of the great ironies, I think, of the Canadian situation is, and you've touched on it, is that we came through a pandemic of 2 years of, you know, a global pandemic, an enormous impact on everybody in the country. And through a lot of that period, there were calls for the government to proclaim a public welfare emergency, but the government never did. And then this convoy starts where you kind of wonder, you know, does the situation justify it? And lo and behold, the government proclaims an emergency.
Well, that's what politics is for people. Politics, yes, they have to justify their power at a certain point.
Thanks, John, for that question. Does anyone else have a question they would like to ask? Now's your chance. Otherwise, I'm going to ask a question, and that might take us to the end. So I'm going to give you going once, twice, 3 times. I am going to ask a question that's slightly different, in part because I'm not really an emergency powers expert, and I'm not a national security expert either, but something that does come across sort of my areas, especially when I teach first-year criminal law. We have the protection of the sort of most fundamental liberties are set out in Section 7 of the Canadian Charter of Rights and Freedoms. And Section 7 protects life, liberty, and the security of the person. And security in that context is not economic security. It's really about security to the physical, and also, you know, to some extent, it encompasses privacy, or, you know, the sort of zone of autonomy of individuals. And in the early days of the interpretation of the Charter, which was first sort of became applicable in 1982, you know, the Supreme Court had to spend a fair amount of time figuring out the frameworks within which these various rights would be interpreted. But one of the things that, you know, early on became a question was, you know, the interaction between Section 7, which is really the protection of very fundamental rights. They're not the only rights that are protected in the Charter, but these are the ones that tend to trigger the most discussion when it comes to things like emergencies and suspension of fundamental liberties, although freedom of expression is also in there in assembly, but I'm going to leave those for on the side. But with our Charter of Rights, we do have a provision called Section 1, which allows for the government to enact legislation or to engage in acts that might violate some of the protected freedoms, should those be justified, you know, an urgent and pressing need, and justified in a free and democratic society. And the court early on elaborated kind of a series of steps to analyze when you might be in presence of such a constraint that you might need to suspend liberties. Now, that's not limited to national emergency, of course, and it has to be an urgent and pressing need, and then there has to be, it's essentially, there has to be a rational connection between that need and the measures used, and then the measures need to be proportional. I'm just giving you the very treetops. But in some of the early jurisprudence, you know, it was acknowledged that the rights protected in Section 7 are really important, and so it would be hard to imagine many circumstances when you would be able to justify, even under Section 1, the suspension of those liberties. But one of the examples that was given in this list by then Justice Lemaire, who later went on to become the Chief Justice, was emergencies, disasters like floods, pandemics. And yet, funnily enough, that's never really actually, it's just Section 7 is pretty much, there's never been a case where where the government has been able to defend violations successfully, unlike some other procedural and criminal law rights, which have been. So I'm wondering whether, in India, there's ever a discussion outside of the specific context of national emergency, discussion of other circumstances where there are suspensions of rights that may not qualify as a national emergency, but might be a similar sort of urgent situation, or does it just always fall within the framework of, emergency powers? I'm just curious whether there are these, let's say, they're on the periphery, or they maybe don't quite meet the standard, and yet there might be a temptation through ordinary legislation to restrain civil liberties. And if so, if that's been examined.
So Professor Jennifer, again, very interesting question. And I think it actually somehow touches upon the question which Professor Sebastian had also asked in the beginning. And what is the difference between India and Canada as far as the state of emergency is concerned, provisions? Now, that is entirely exactly what I was saying was that in India, it is provided under the Constitution. And the fundamental rights are provided under the Indian Constitution. So as far as that point is concerned, no law, no statute, no provision can be made which takes away the fundamental rights. So laws, ordinary statutes cannot take away the fundamental rights at any point of time. That is the meaning of the fundamental right being provided in a constitution. Number two, the only time that the Constitution allows for the suspension of the fundamental rights is during emergency, which I was speaking of. And this is only during national emergency. It's not suspended during state emergency. It's not suspended during financial. So only during times of war, external aggression, or armed rebellion, if national emergency is invoked, will the fundamental rights be suspended. And it's only Article 19, one of the fundamental rights, which is the right itself is actually suspended. The other fundamental rights are not suspended, but the right to move to the court to redress your grievance for violation of these rights is suspended. So you can wait for the emergency to be over and then go to the court because the right was available, but you cannot go to the court during that period of time. The other time when it is provided in the Constitution itself in India is when martial law is in application in an area. So if a particular territory is under the military because of certain reasons, X, Y, Z, during that time, it is not possible for the fundamental rights to be followed. So these are the only situations when specifically the fundamental rights are taken away. And like I said, the only time when these fundamental rights were actually denied to the people of India was that 21-month period from June 1975 till March 1977. There has never been a time when the fundamental rights were not available. Secondly, as far as the Canadian context is concerned, this is really the question that you have the Charter of Rights, which has a constitutional status, and then you have a legislative enactment, which provides for a state of emergency. Now, can an ordinary legislative enactment, a statutory law, can it take away the constitutional rights of the people? So that is a question which I think Canada needs to explore, because if it was in India, the answer would be no, it cannot. A law enacted by the parliament cannot override the fundamental rights, which are provided by the highest law of the land under the Constitution. And that is given in the Indian Constitution itself under Article 13 of the Constitution of India. Yeah,
I think the answer here is that it depends on the analysis under Section 1. And this is where my area of expertise peters out, but I think that's the question that, the 1988 legislation was intended to address concerns about abuse and the ability to use it capriciously and so on. But then there's the actual using of the legislation. So the legislation as enacted might be capable of being seen as valid or interpreted as valid, but then the question becomes when it's actually used. I think that the critical issues here aren't the suspension of civil liberties, because there weren't really that many. They were very specific in the sense there wasn't a general suspension of liberties. It's rather how government and police powers were used. But I think the larger question was what was it about the state of emergency that gave something additional that wasn't available before the emergency? And I think that is where there's just there's going to be a difference of opinion about that for as long as there are going to be discussions about what happened in February. And I think it has to do with the fact that it's not clear what changed and why it was necessary to proceed in this way, except that there seemed to be a very chaotic and poorly coordinated use of existing resources. And was the Emergencies Act necessary to provide that coordination? Many people are a little bit skeptical, and so it's a difficult process. At the same time, of course, it's hard to situate oneself in the emergency or in the state of crisis, let's put it that way, when you don't know what the outcome is going to be, and when you're at certain points where it looks like an escalation could be very serious, and yet it doesn't turn out that way. Hindsight is always 20/20. So it's interesting, I think. I'm going to ask you one last question, and then after that, I think we'll pretty much finish perfectly on time. It's interesting, the notion of state emergencies, because we do not have that. We don't have that concept here, at least provinces have, and part of that has to do with the way our division of powers is, but it's also, I'm not sure that any province has thought about that kind of a concept. I'm wondering, is there given the substantially greater use of state emergency powers, what's the public and legal perception of state emergency powers versus the national emergency powers?
Yes, Professor Jennifer, that's again, actually in India, the fact that it's been imposed 133 times and one state is still under a state of emergency at this very moment, the state of Jammu and Kashmir. Normally, the grounds on which it is imposed is different from the national emergency grounds, because as far as the Indian Constitution provisions are concerned, the Constitution obligates the center to protect the states. And this may happen, they may need to step in, especially when there is a huge law and order problem. So that is one situation. And that situation did occur in Punjab, the area where I reside, way back in the 1980s, because Punjab was under a state of terrorism at that point of time. The center had to step in with all its resources to tackle that. And that is the successful story of elimination of terrorism in that particular state through the use of emergency powers. Okay. Now, the other ground which is usually the more frequently used, or rather misused ground, is the political context. Now, what happens is that if the party which is in power at the center is different from the party which is in power at the state level, there is bound to be conflict in terms of the governance issues. And that is usually the time when the party at the center would like to exercise its power over the state and would like to dismiss the government of the day in the state through the misuse of Article 356 provisions of state emergency. So it's more, that is why the 133 times that it has been imposed, a lot of it has been for misuse of power. The political context where the state government is dismissed on certain grounds, whether it is that the constitutional machinery has failed, the administration of the state is corrupt, and it cannot be carried on, or whether they do not have the numbers in the legislature to run the government. So these are various issues, and these are always, as far as the states are concerned, I mean, this is a political battle, and the misuse has happened at this point of politics. That is why the Supreme Court has decided in 1994 through the S.R. Bommai judgment that there are certain guidelines without which you cannot impose state emergency. So the reasons for imposition of national and state emergency become extremely different. And the misuse has actually led to the state emergency becoming the most controversial and the most misused provision of the Indian Constitution in that sense.
Well, thank you for that answer. I see that John has corrected me. There is emergency legislation. It's just, you know, it obviously in Canada, there would be a territorial delimitation to that, but it's not imposed by the federal government. It's a provincial legislation that would empower the provincial executive to take measures. So it's a little bit of a different context. I think this is a good place to conclude. I don't know if you have any concluding remarks, Shruti, but this was a really fascinating presentation, and I think that there are lots of questions and comparisons that you've raised that will continue to germinate for the Canadians who were on the call. But I hope it was also of interest to those who joined us from other parts of the world. So I'm going to give the last word to you, and after that I bid everyone a good afternoon or a good night, as the case may be, and look forward to welcoming you all to our next conferences, which will start in January of 2023.
Thank you, Professor Jennifer. It's been an absolute pleasure and an honor to be able to speak on this subject, which is extremely important to me as well, because we did do a lot of research. In fact, we did explore the theories, the different models of states of emergency. But of course, the time here is short and we were not able to get into that. But yes, I also feel that the Canadian situation can be compared with the Indian context. And maybe, you know, because India has had the experience of learning a lot from the previous laws the other countries had. And it's always the comparative constitutional law, which is extremely important to incorporate in the context of your own situation. So learn lessons from the other countries and from the mistakes that they've made, so as not to repeat them. And I would just like to end with that, you know, especially in the context of the question that you had asked earlier, that the areas as to when the civil liberties of the Canadian citizens may be suspended has not been really put down in black and white. I think that's an area which really needs to be taken care of, because as time goes by, these are the problems which naturally crop up. And as we have seen in India, this is what is really needed to be protected. And that is why the Indian courts had to evolve the doctrine of basic structure, that there are certain things in the Constitution which cannot be taken away. So fundamental rights, although it's not been clearly stated, but for example, right to life, for example, right to equality cannot be taken away ever from the Constitution of India and from the people of India. So that's something which jurisprudence from other country really helps with. And I think the Canadian context is extremely relevant. And I, for one, I'm waiting to look at the decision of the courts in Canada as far as this imposition of this emergency is concerned, to see how it goes. So thank you so very much for having me, for all the questions which have actually also made me think a lot in a different context. And I think I would like to incorporate that in my writing somewhere. So thank you. I express my gratitude to Professor Jennifer, her team, and the Civil Law Center, and everyone here today. Thank you very much. And good afternoon and good night.
Bye-bye, everyone. Thank you for joining us.